Hi, my name is Ricardo Wyngaard, and in this video I want to briefly comment on the issue of whether or not the executive director of a non-profit should be a voting board member on the organization's governing board. I know that there's been some discussions and I often get this particular question from people at workshops via email, and I thought, let me just make some introductory remarks on this particular issue. Now, in terms of legislation, there's absolutely nothing that prevents or the executive director to be also a voting board member. That's now in terms of common law for the Voluntary Association. The Trust Property Control Act doesn't prohibit it, neither the Companies Act. In fact, if we look at the King 4 Code on Corporate Governance, it recommends that there should be at least 2 senior management on the board, and there's, in terms of the governance, also no practice prohibiting the executive director to be a voting board member. Having said that, I do think it's important for organizations and for the executive director to take certain factors into account. The one is that once you become a board member of the organization, you sign up in terms of the organization's founding document and also the relevant legislation, and you must adhere to the standard of conduct that's expected of a voting governing board member of an organization. Now, that might be different if you're just an employee of the organization. You still have you still have to comply with certain standards. For example, in terms of your fiduciary obligation, that's not limited to a board member. So a staff member would also have a fiduciary obligation to the organization. Even an independent contractor in certain contexts would have a fiduciary responsibility. But if we look, for example, at the Companies Act, there are other standards of conduct that are applicable to board members of organizations and also committee members, subcommittee members of an organization. Those standards are not necessarily automatically applicable to staff members of the organization or the executive director. So when making that decision, it's important that the executive director also understands that he or she will now have to comply with the standards of conduct as a board member, as set out either in its founding document or in terms of the legislation. So it's in a different capacity that the executive board member will now serve the organization, and it's got legal implications for the executive director as well. Secondly, what I consider to be important is to have an effective governing board in place. If the vote of one person, the executive director, is a big concern in the organization, because I often hear people saying, well, the executive director should not have a vote on the board because he or she will influence the board in making decisions. Now, of course, the executive director should have an influence in terms of governance. That is, whether or not she or he has got a vote on the board or not, there will be some influence. But the board, if it is to be effective, must be able to make decisions, informed decisions for the organization, and not be led by the executive director on issues of governance, because the governance responsibility for the organization is vested with the governing board, not with the executive director. And it's important to keep that in mind, that the executive director has got a delegated function, delegated from the board to the executive director. That is a very important relationship within the organization. So it must be important that the relationship is constructive, whether or not the executive director has got a vote or no vote on the board. There must be influence, from the executive director to the board. But we must always keep in mind that the ultimate governance responsibility is with the governing board of the organization, and the governing board will have to account for the execution of its governing functions. So if there's any concern that the executive director will take over control of the organization, in my view, the problem is not with the executive director, it's with the governing board not fulfilling its function. Because let's say you've got 5 or 7 governing board members, there's no way that one person should then control the outcomes of the organization. If you've got that particular context, then it means you've got a weak board, a board that doesn't understand its governance function. And that has to change. Not so much an executive director who is influential or strong-willed. It should be the board taking up its responsibility in terms of governance. So there are a couple of factors to take into account in making this decision. In some cases, you may have to change your founding document if you want to make sure that the executive director has a vote on the board, because that would be regarded as ex officio, meaning the executive director serves in that capacity because of her position as the executive director. So I hope this video has been helpful. If it has been, please click the like button. If you think others will benefit from it, please share. And thanks again for those who are sharing and liking the video.